Summer can be a bit of a slog. For us, it's often for some reason a rather busy time, and I'm sure we're not alone.
Well, you can beat the summertime sadness and the August angst and enhance your everyday with our excellent sponsor, Via Hemp. This is a company that crafts award-winning premium THC and THC-free gummies.
Each of these gummies is especially designed to cultivate a specific mood. Whether you're looking to get relaxed, get quality sleep, get creative, or just to get focused. If you're 21 or older, you can experience it for yourself and get 15% off your first order with our exclusive code MSheet at viahemp.com. That's VIIAHEMP.com.
I personally enjoyed their grapefruit flow state gummies. This CBG and CBD powerhouse really helped me tap into my productivity. Like, we have had an extremely busy summer, and I feel flow state got me over the finish line a few times when I was editing multiple episodes a day, digging through documents, and knocking out a bunch of interviews.
Via Hemp does not require a medical card, and it ships legally to all 50 states. It's also affordable, and even more so for Murder Sheet listeners who get a special deal.
If you're 21 and older, head to viahemp.com and use code MSheet to receive 15% off. That's VIIAHEMP.com and use code MSheet at checkout. After you purchase, they ask you where you heard about them. Please support our show and tell them we sent you. Enhance your everyday with Via.
Temp check. What kind of summer are we having this year? A family road trip summer? A beach bum summer? Or a wake me up when the sun sets summer? With Instacart, choose your own adventure and skip the shopping side quests. Where available, you can get ice cream delivered to your hotel, sunscreen to the pool, or cold brew to your bed. Well, door, in as fast as 30 minutes. Wherever you find yourself this summer, you can get the goods. Download Instacart for free delivery on your first 3 orders. Offer valid for a limited time. Minimum $10 per order. Excludes restaurants. Additional terms and fees apply.
Okay, it's time to commit. 2024 is the year for prioritizing yourself. Begin your new smile journey with Byte, and you could start seeing results in just 2 to 3 weeks. Just order your at-home impression kit today for only $14.95 at Byte.com. Byte clear liners are doctor-directed and delivered to your door. Treatment costs thousands less than braces, plus they offer financing options, accept eligible insurance, and you could pay with your HSA, FSA. Get 80% off your impression kit when you use code WONDERY at Byte.com. That's BYTE.com. Start your confidence journey today with Byte.
Content warning. This episode includes discussion of the murder of 2 children.
Today on the Murder Sheet, we're going to be going over some of the recent developments in the Delphi case. That concerns a very, very interesting filing from prosecuting attorney Nicholas McClelland, as well as another somewhat less interesting document from attorney for the attorneys, David Hennessy. My name is Anya Kane. I'm a journalist.
And I'm Kevin Greenlee. I'm an attorney.
And this is the Murder Sheet.
We're a true crime podcast focused on original reporting, interviews, and deep dives into murder cases. We're the Murder Sheet.
And this is the Delphi murders, Admissibility and Demeanig commentary.
Before we get to the filings that Anya mentioned, let's just hop back for a moment to the hearing that was held last week. The hearing, of course, that Anya and I were not able to attend, to our regret. I think there's still some confusion about what exactly happened there. Essentially, the defense came in and said, we need longer than the scheduled time for the trial. And the fact is, the trial had been scheduled for a 2-week duration all along in the process. From the first time it was originally put on the calendar and inevitably postponed probably a year ago, it's just always been a 2-week time frame. And they did not indicate that there were any issues with that until almost literally the very last minute. I think you had something.
Yeah, and let me just, before I have my little analogy, I feel like it's important to stress that most murder trials are not necessarily that long, even ones that seem complicated. So people often express surprise about 2 weeks. How could they possibly do everything in 2 weeks? Well, most cases seem to manage to get by with that amount of time, or even less. One could argue, perhaps correctly, that Delphi poses some unique challenges. I'm not really disputing that, but there is a certain point where duplication of witnesses and sort of like making the same point again and again and again, and leaving less room for grandstanding on both sides, does become something that is actually desirable. So, but anyways, we can argue that Delphi, again, given the scope of it, perhaps needs some extra time. To me, what really has stuck with me as I've been thinking about it afterwards is how the defense went about doing this, how they went about asking for more time. And I guess I came up with what I feel is an analogy that kind of describes perhaps how I take away how this all went down. Let's say Kevin and I are a couple. I mean, we are. But let's say in this version of reality, we're hoping to take a vacation. And both of us have agreed and understand that a vacation is 2 weeks long. And that's what we've always discussed. And that's what we've defined as a vacation. And those discussions have been going on for months. We've been talking about this vacation for a while, planning it. And so at some point, I'm really stressed out. I turn around and tell Kevin, I need a vacation in May. We gotta fast track this thing, or I'm gonna have a meltdown. So Kevin clears his schedule and we make room for it. And then a few days prior to us heading out to our vacation, I suddenly object, saying that I really need a much longer vacation because I'm not going to be able to fit in all the activities I want to. So the issue there is not the fact that I asked for a longer vacation. Maybe it's reasonable. Maybe my activities are freaking dope and we're going to have a great time. And I need I need more time to relax because I'm really burnt out. So it's not really the fact that I asked for more time that's the issue here. But doing so at the last minute and then getting mad if Kevin has stuff booked for, after the 2 weeks where that would basically prevent us from going on a longer vacation, that does seem unreasonable. Perhaps Kevin is slightly at fault for not asking me or not checking in and double checking earlier. But it seems a little bit arbitrary for me to be suddenly objecting to that in May. So, yeah.
Yeah, and I think that's an important distinction to make because there's two different issues here. One is, how long does the defense need to present its case? And everyone agrees that they should have a fair amount of time to properly present their case. And I frankly felt that a 2-week time frame for the entire trial was a bit short. So, with that said, if the defense shared the concerns I had about that being too short, then perhaps they could have informed the judge of those concerns earlier in the process because she put the 2-week trial on the schedule some months ago.
And also, they conveniently wait till the moment, where it's too late because the jury questions have been sent out.
And the judge indicated that her understanding of the rules is that once she has sent these forms out to the jurors saying a 2-week trial, then that can't be stretched out or changed. I've seen people say, well, maybe Judge Cole's not right about that. Maybe she is. But that does seem to be her interpretation of the rule, and it seems to be a fair interpretation of the rule. And so once those questionnaires have gone out, her hands, in her mind at least, are tied, and she can't change the length of the trial. But again, the defense knew what the scheduled length of the trial was prior to her sending out that questionnaire. And so if they had those concerns, they could have shared them then. It's difficult to believe that they suddenly woke up on the morning of April 30th and realized they needed more time.
I'm just going to say this, and please keep in mind, this is my personal opinion. I'm not speaking as somebody who has all the answers here. I'm just viewing this from the lens of an outsider who's just familiar with what's going on here. And I feel like the 2 weeks issue was somewhat, at least partially, pretext to ensure that May did not happen for trial. I don't think that this team was ready. I think there's been a lot of sort of obfuscating discussions online about how they were tricked into October. I think the defense team made this call because they realized that they were not in any way ready and could not become ready within the, course of a few days, and they needed more time. And listen, from the perspective of wanting this to be a fair trial for Richard Allen, that's a good decision. you shouldn't be racing into this. I think the whole thing about the 2 weeks thing, I mean, I'm sure they do feel they need more time. I don't think that's insincere. I just think the way they went about doing this was to basically delay trial. And honestly, I question whether or not they were ever sincere about May. So I guess I'm very skeptical here. And I think some of the discussions I've seen have really missed the point where people seem to think this was like the judge's trump card of like, haha, we're delayed. I think out of everybody involved, I think my guess, and again, I don't know this, but I have a feeling that Judge Gull probably wants this done and to be over with. I think the prosecution's ready to go. I do not think the defense is.
My own observations when I look at the judge, when I look at the prosecution team, when I look at the family members, when they were in court for the hearings, none of these people are having fun. None of these people are like, oh, let's prolong this great experience. I think they're ready for it to be over.
I think the defense is probably not having fun. I think their reputations have been tanked by this whole situation, frankly. Whether that's rightly or wrongly, we could debate, but I think they are looking to not humiliate themselves at a trial. And I think had they gone forward in May, they would have.
So you're saying in your mind this was a face-saving attempt by them to delay the trial?
100%. And they're very much about saving face because sometimes it seems like that's all they have.
Have you ever covered a carpet stain with a rug, ignored a leaky faucet, pretended your half-painted living room is supposed to look like that? Well, you're not alone. We've all got unfinished home projects. But there's an easier way. Thumbtack is the app that makes it easier to care for your home. Pull out your phone and in just a few taps, search, chat, and book highly rated pros right in your neighborhood. Download Thumbtack and start caring for your home the easier way.
This episode is sponsored by AutoTrader. Credit scores, down payments, interest rates. Car buying can be a numbers game, but you don't have to be a math expert to get the keys to your dream car. Just use Kelley Blue Book My Wallet on AutoTrader. Crunch your numbers and get your personalized results so you know exactly how much you'll pay each month for your car. It's like having a magic wand for your wallet. Presto! The car you've been wanting is now within reach. So hit the road and leave your calculator at home. Find your next car on autotrader.com.
Should we move on to the state request for pretrial ruling on admissibility?
This one's one of those This is one of those filings where you read it and you're like, oh my goodness.
It's a pretty short filing. You seem to be in fine voice. Do you want to just read the whole thing?
Sure. So, quote, comes now the state of Indiana by prosecuting attorney Nicholas C. McClelland and hereby requests a pretrial ruling as to the admissibility of certain communications made by Richard Allen to a psychologist. In support of this request by the state submits the following. 1. That Richard Allen has access to mental health services at the Indiana Department of Corrections, where he has been housed for safekeeping pursuant to court order. 2. That mental health personnel employed by the Centurion Health provide psychologists and or counselors to whom Richard Allen has made statements. 3. That in particular, Dr. Monica H. Walla, a psychologist licensed to practice in the state of Indiana, has documented statements of Richard Allen, which the state believes fall within an exception to confidentiality, pursuant to Indiana Code 2533-117. 4. Indiana Code 2533-117, privileged communications between psychologists and clients, states in part, a psychologist licensed under this article may not disclose any information acquired from persons with whom the psychologist has dealt in a professional capacity, except under the following circumstances. 1. Trials for homicide, when the disclosure relates directly to the fact or immediate circumstances of said homicide. 5. The state intends to offer into evidence the testimony of Dr. Monica Walla, as documented in her reports entitled Department of Corrections Behavioral Health Suicide Observation. 6. That the state seeks this ruling for the sole purpose of expediting in the presentation of evidence during trial, to put the defendant on notice as the evidentiary exception, and to obtain a pretrial ruling on admissibility. Wherefore, the state requests the court provide a ruling as to the admissibility of Richard Allen's statements through testimony of Dr. Walla, testimony per the exception cited in IC 2533-117-1, and for all other just and proper relief in the circumstances. Quote.
So that's a lot of words, many of them with multiple syllables. So let's parse this out a bit. They're saying that they want this Dr. Walla, to come in and talk about some statements she received from Richard Allen. And then we look and we see that basically under Indiana law, she's only allowed to do this if these statements relate directly to the fact or immediate circumstances of said homicide. So it seems pretty clear. We don't know this for a fact, obviously, but it seems pretty clear that we're talking about a confession.
This is one of those things where you just need to read the filing and it basically tells you what's happening here. He's made incriminating statements, or he's confessed to this psychologist.
He's made statements related directly to the facts of the homicide.
Yeah.
And let's go a step further. We know that this is not the only confession he's made. He's made confessions reportedly to as many as 30 different people repeatedly. So why are they trying so hard to get this particular confession in? And an educated guess would be that maybe this confession is a really, really good one, a really strong one. And so then you say, Kevin, what do you mean? Aren't all confessions created equal? And I'll tell you what I mean. Let's say, for instance, that Anya comes on the show and in a fit of remorse says, I stole cereal. Okay, that's interesting. It's incriminating. But does it really give us a lot of information? What if Anya comes on the show and says, I stole cereal at this particular supermarket at this particular time? Is I was walking in, I saw my neighbor who was wearing this particular piece of clothing. I saw these other people in the store, and so on. If she gives a lot of detail about what she saw and experienced as she was stealing the cereal, that makes the confession a stronger one. Does that make sense?
It does. And I'd like to add a little bit of a caveat here, because you've been using the word confession a lot. And what the documentation in the filing so far has described these often as incriminating statements. What is the difference? I see a confession as somebody sitting down and saying, I did this, here's what I did. An incriminating statement could be something that aligns with a confession or certainly points to guilt, but it's not necessarily quite as bombshell. So I would say, reading this document, my inclination would be that this is more on the confession side of the spectrum than incriminating statement. Like, if you're going around saying, I feel so bad about what happened on February 13th, 2017, that's somewhat incriminating, but it's not necessarily a confession. Maybe you're complaining about something else. But this, to me, strikes me as, and also the setting of a psychologist, where you're unpacking your trauma, your concerns, your anxiety, your depression, what have you. That, this seems like it could be very, very bad for Richard Allen.
Yeah. whatever Dr. Walla documented from Richard Allen seems like it would be especially bad for him and for the case.
For his case, but very good for the prosecutor's case.
Yeah, and again, I think it must be something important for them to try to get something in from a psychologist. There is clearly that exception written into the law, but I think some people have. We like to think of when we talk to a therapist or a psychologist that it is private, and we value confidentiality very highly, but and we do. But it's also important to remember that in society, we don't value, it's always a balance of interests. We don't always value everything the highest possible way it could be valued. I'm a huge fan of the First Amendment. I'm a free speech absolutist. But that doesn't mean that I believe Anya has the right to come on the podcast and broadcast my social security number.
Oh, well, what are we going to talk about for the rest of the episode then? Because that was my plan.
So in other words, the things we value, they have to be balanced against other values. And the state of Indiana, you may agree with them, you may not agree with them. They have written it into law that getting information about a murder from the murderer trumps patient confidentiality.
It is so brutal how, aptly that fits this situation, that one exception of just, trials for homicide specifically, where the disclosure relates to the facts or immediate circumstances of said homicide. And yeah, that's exactly what, it's not saying any felony, it's talking about homicide. And obviously we have a double homicide here. I think this, to me, there has been so many disastrous moves by Richard Allen himself in this. You could argue they're disastrous if he's somebody who wants to confess, if he's someone who wants to unburden himself because he is guilty. Then it's not disastrous from his point of view. It's like he's trying to possibly do the right thing if that's the situation.
Yeah, that's something I'm struggling with, because I think when we look at the case against Richard Allen, it has become a lot stronger than it has been in the past. And the reason it's become stronger is because Richard Allen is making all of these incriminating statements or confessions or what have you. And we haven't seen anything to indicate that he is severely mentally ill. There hasn't been any question that he's competent to stand trial. We've seen details about alleged breakdowns and stuff. But unless he is severely mentally ill, if he's rational at all and he is repeatedly admitting complicity in this crime, then we have to, at some point, does he want a trial? Does he want a trial? Does he just want to plead guilty and have this be over with?
I want to unpack that for a minute, but first I'll say this. I think you're completely right. I think that I would go as far as saying at this point, from what we know publicly and what we're putting together from some of these filings, this is a very strong case against Richard Allen. And it would take a detailed and reasonable explanation that would undo a lot of the damage he's done in order for me to say otherwise. It would take, we've talked about situations, you almost never want to put your client on the stand when you're a defense attorney in a case like this.
Almost always a bad move.
It's almost always a bad move. It pretty much, most of the time it is a bad move. The one reason we've heard from defense attorneys that it can be helpful is if there's something kind of inexplicable to the jury and you think your client can explain it and kind of almost undo it. I feel like you'd almost need to hear from Richard Allen. Why the heck were you saying this the whole time, man? What are you doing? And if he says, listen, I have this specific psychotic situation. I feel really guilty. I didn't do it, but I just feel horrible about the whole thing. And I'm we can maybe hear him out on that. But at this time, barring something like that, something along those lines, it becomes very hard to explain all of this, in my view, because we're not talking about one or two incriminating statements made in a moment of darkness or weakness. We're talking about a prolonged pattern that is sort of baffling from anything other than a mental health issue standpoint. And I'm going to say this about whether he wants a trial or not. I am so baffled and concerned about that issue in particular right now. and I'll explain what I mean. This is a man who seemingly is telling everyone who will listen incriminating details about what he says he did. And we've seen, a very much factual innocence basis from the defense team from the beginning, even before they even got to most of the discovery. There's a problem there. And what I want to know is he allowed to plead guilty at this point? Like, does he have that freedom at this point to do what he wants to do? Those are questions that concern me. In a normal case, I would say obviously he does. But at this point, I mean, is he being listened to as a client? Now, you never want to, as a defense attorney, you can never go in and say, hey, did you do it? Do you want to plead guilty? That's not a good idea. That's not how it's done. You let the client come to you. But my question is, if he goes to this team and says, you know what, I did it. Let's change the plea here. Are people open to that? Are people receptive of that information? Because I can't imagine what it would be like to want to have something be over with and to be dragged through this experience regardless. That sounds like perhaps something out of a nightmare.
And if we assume, for the sake of argument, that he is guilty and he has any remorse whatsoever, you imagine it would be helpful to him to take responsibility and stop putting the families through this nightmare.
Yeah, and his own family, frankly. And I'm going to say this. Things that have come out about his relationship with his attorneys concern me. The thing that I keep going back to is William Libredo, who at one point was his defense attorney, who is now off the case. He made a comment to Court TV indicating that Allen seemed to be under the impression that he would have to pay for the services of William Libredo and Robert Scrimmen, and unless he got his old attorneys, Andrew Baldwin and Bradley Rosie, back, he'd be out of pocket. That's obviously not true.
Not true at all.
So where was he getting that? Is that him trying to save face and not wanting to hurt Scrimmen and Libredo's feelings? Or is that him honestly telling them what he thinks? And if so, where is he getting that misinformation from? Like, where is that coming from? He does not strike me based on a comment like that. He does not necessarily strike me based on the fact that, the Judge Gold did not have an initial hearing or did not have him in her chambers to discuss what was going on.
Yeah, Judge Gold did this cause a real disservice when she did not have Richard Allen come into her chambers in October, or barring that, having an open hearing in October where it was clearly explained to Richard Allen exactly what the issues were.
Yes, we have a letter from him saying, I absolve my attorneys of wrongdoing, but it only gets into the fact that Mitch Westerman took images of discovery and distributed them. It doesn't get into strategy leaks by Andrew Baldwin. It doesn't get into anything else. So I'm not necessarily confident that Richard Allen is an informed client and is a client who is empowered by all the information he needs to make decisions in this situation. I'm just not. He could be. He could know everything and be fine with everything, in which case, great, because that's how he should be. And that would make me feel a lot better if I knew that he was. But I'm not confident. And I just want to know, what does he want to do? Is he being dragged through a charade at this point? Or is he saying, I made those incriminating statements, but I changed my mind. Let's go for it. Let's roll the dice.
Yeah, when a man makes that many incriminating statements, you do have to wonder, does he want a trial? Does he want another outcome to this?
And again, I can't get over, we've learned through filing after filing from the defense oftentimes themselves that they've, only recently gotten to certain aspects of discovery. So the fact that they were putting out, from the jump, it has to be factual innocence. Well, you haven't read anything at this point, so it's pretty easy to say that immediately. But then the fact that they're sticking with that, okay, well, that's fine. But it just feels like having an open mind when you're a defense attorney is important. And also there's ways to zealously represent a client that are also very important. It's not like a good defense attorney gets there and the client wants to plead guilty and it's like, all right, well, you deserve everything that's coming to you. Like, you still have to do advocacy. You still have to ensure that they're getting the best deal possible, or that there's, you're maybe arguing it from murder to a manslaughter. Like, there's avenues there to continue to advocate that don't just necessarily conform to the media friendly, exciting trial of the century narrative, let's just say. So I'm concerned.
Shall we move on?
Let's move on. So next, okay, this is move on to this section. We're gonna have some Demeaning things to say.
Yeah, David Hennessy filed a motion about Demeanig comments from the judge, and as you can note, he in the very title of the document, he misspelled the word demeaning. And this is really characteristic of the sloppiness and lack of care we've seen in a lot of his filings and, frankly, in some of his performances in court. We're talking about this filing. Basically, it is the judge said some mean things. I wanted to take them back.
Can you just tell me how unusual it is to have this is not, if we're not trying to be jerks. If this was a singular error in a title, I don't think we would make that big of a deal of it, because everyone does typos. I mean, we're not above that. But his filings have been peppered with errors since the jump, to a degree that I find surprising as a non-attorney. How do you feel about it?
I find it surprising as an attorney.
And I'm going to
when we first started filing into the case and having some typos, I think we didn't mention it because, as you say, everybody makes typos, but he makes so many of them. You once said, memorably in my mind, that his filings read like he wrote them as he was rushing to catch a bus.
David Hennessy knows lawyers who use spell check, and they're all cowards. I mean, like, I do not understand this, and it's sloppy. It looks bad. It's not just typos, though. It's not just misspelled words. He's gotten names wrong.
Dates wrong. I mean, whole years wrong.
Yeah, this is not good work. It's, I mean, like, so what is the service of this, disastrous filing in terms? Basically, Judge Gull said mean things. Take him back, please. This is a guy who compared the sitting judge in this case to Gollum from Lord of the Rings, so not even a particularly good burn, to be honest, but
I don't think he really expects her to take those things back. And after all, he did win. She did not find his clients in contempt. I think he's trying to build a record for an appeal here. But along the way, he makes some truly nonsensical arguments. And
I'm going to tell you, my interpretation is that he won not because of anything this doddering hanger-on did, but because McClellan did not get to the level of proving beyond a reasonable doubt that Andrew Baldwin ordered his former employee and close friend Mitch Westerman to leak images of dead children on social media beyond a reasonable doubt. I don't think the prosecution achieved that. I think Hennessy played patty cakes with a bunch of YouTube cranks, and that's what his contribution was. But I think it was McClellan's failing rather than Hennessy's win, as far as I'm concerned. And honestly, strategically, it makes sense for the judge to do this at this point, because it makes it harder for them to complain on appeal.
One of his more nonsensical arguments is point 7, where he basically says this judge has never represented a client in a criminal case, so I guess the implication is therefore she's not qualified to rule on the behavior of criminal defense lawyers. Obviously, there are many judges who have never represented defense clients. There are judges who have been defense attorneys who never prosecuted a client.
And you don't prosecute your own clients, but never prosecuted a defendant. I mean, there are some lawyers who do both. They go into the prosecutor's office, then they do defense, or vice versa sometimes. But
you don't have to have specific qualifications to be able to work as a judge. You don't have to have check specific items off a resume. It's not like I say, Anya, you call yourself a podcaster. You've never worked on a motorcycle engine. It's ridiculous. And also, one of the whole precepts of our legal system is, if Anya is prosecuted for stealing all of this cereal, can she only be judged by cereal-loving podcasters? Or do we imagine that other people who are intelligent, who've had a wide range of experience, can also judge and convict her?
I'm going to say this. There's one thing I come back to with Hennessy. I remember when he interviewed with us, there were a lot of bitter complaints about a certain female prosecutor that seemed a lot more personal than some of his complaints about other attorneys that he's come into contact with over time. And so that's something that I think about whenever I'm seeing stuff like this. It's just something to note, I think. And I guess I don't really understand why he's still here. I mean, the contempt hearing is over. I guess he told us he was nearing retirement, needs some activities perhaps, but if I were Rosie and Baldwin, I would probably be in a position where I might say, thank you for your help, bye. Because I don't see what he's adding to this team aside from a bunch of embarrassing filings at this point. And I think it makes sense on some level to create a record for appeal. But I also don't see that working out because the judge has discretion with which to say that their behavior was appalling even if I don't find them in contempt. I think what a higher court is going to look at is the not finding them in contempt aspect of that. Because ultimately that matters more.
Anything else you want to say about that?
Nope, I think I'm good. How about you?
I think I'm good too. So thank you so much for listening, and we will chat again soon.
Thanks. Bye.
Thanks so much for listening to the Murder Sheet. If you have a tip concerning one of the cases we cover, please email us at murdersheet@gmail.com. If you have actionable information about an unsolved crime, please report it to the appropriate authorities.
If you're interested in joining our Patreon, that's available at www.patreon.com/murdersheet. If you want to tip us a bit of money for records requests, you can do so at www.buymeacoffee.com/murdersheet. We very much appreciate any support.
Special thanks to Kevin Tyler Greenlee, who composed the music for the Murder Sheet, and who you can find on the web at kevintg.com.
If you're looking to talk with other listeners about a case we've covered, you can join the Murder Sheet discussion group on Facebook. We mostly focus our time on research and reporting, so we're not on social media much. We do try to check our email account, but we ask for patience as we often receive a lot of messages. Thanks again for listening.